All right, how y'all doing? Today we'll be drinking from the Max mug. This Max mug was a Christmas gift he made at school, and I guess we bought it, so not much of a gift. I think you could say it's artistic, but I also just think he probably did it in about 4 minutes. Salud. Today's topic is the Warren Court. This is weird that we're referring to a court by a name, and that's because we often reference certain eras of a Supreme Court by the Chief Justice that was in charge. Chief Justice Earl Warren was appointed by President Eisenhower, a Republican president who probably hoped he would be a conservative justice. Earl Warren served as the governor of California, so he had been around the block for some time. Earl Warren is shown here with his 8 other Supreme Court justices. He sits in the middle. Other famous names here are people such as Hugo Black and Judge Harlan. Black to the left and maybe Harlan to the right politically. So what I'm hoping to do today is go over a few Supreme Court cases, some in more depth, some I'll just gloss over, but all of them help define the 1960s and help define our political and judicial system today. They're kind of all made up of like unique stories that for some reason you start rooting for the suspected criminal because the suspected criminal wasn't having their rights protected. Do understand that a few of these cases are about some seedy, shady characters who are not people we're going to have you come home with your to visit your mom and dad. But in America, their rights need to be as protected as the rights as the good boys and girls, the ones that are watching right now. So, citizen number 1, this is a Supreme Court case called Mapp versus Ohio. Mapp was being charged by the state of Ohio. So, Dolly Mapp was involved in an underground, seedy numbers game in Ohio. She was a criminal with suspected criminal friends, to the point where the police came knocking to her house looking for somebody, and at her apartment, and she said, no, go away, you don't have a warrant. Well, they came back hours later, jammed something in her arms, and she jammed it away, and there was an assumption that it was an actual search warrant. This is part of the story, right? So in looking in her apartment for a person and for items, nothing is found. Well, nothing that they were looking for was found. What they did find was some pornography. And trying to make sure they have something on her, she eventually gets charged with having pornography, which in the 50s was considered illegal in that state. This goes all the way up. She appeals this all the way up to the Supreme Court. And eventually the Supreme Court rules in Mapp versus Ohio that the pornography found in her apartment was inadmissible in court because no one could prove there was a search warrant served. So this is where we get the term exclusionary rule, that police and the judicial system cannot use things that were found without A, a search warrant, or B, probable cause. Well, there wasn't a probable cause at the time to be entering her apartment. It's not like a criminal had just run in with a knife. So they found it based off of what they were trying to say was a search warrant, which they could never demonstrate they had. So she wins, though she did have illegal pornography at her house. So remember, we're rooting for the criminal. Here's another example. So this is Gideon versus Wainwright. You could see Gideon was an older gentleman who got involved himself in some just low down lifestyle. He did not have a lot of money to himself, wasn't making a good living, and maybe because of that, he helps rob a pool hall. He robs a pool hall. So when they bust him for robbing a pool hall of like change, lots of change, but nonetheless change, he goes to court. And he does not have anybody defending him because he had no money to pay for a lawyer. He goes to jail. So sitting in jail, he starts to find that the federal government allows, in a federal case, every single person to be given some sort of court representative. But at a state level, there wasn't that rule. And that's where Gideon versus Wainwright kind of changes things for the future. In the court case, Gideon versus Wainwright, that goes all the way up to the Supreme Court, that the defendants have the right to a lawyer no matter if they can pay for a lawyer. They will get a lawyer appointed to them for free. This is something that I think you probably heard of, but these things weren't part of our founders' plan. This is the stuff that emerges after court case after court case. Next one, Escobedo versus Illinois. I believe Escobedo, they think, shot his brother-in-law, all right? And Escobedo then is taken into custody where he is not charged, but they keep questioning him. He says, "Can I have a lawyer?" They say, "No, because you haven't been charged. We are holding you without a charge, but because you haven't been charged, you don't have the right to ask for a representative." ... So Escobedo goes all the way up. Escobedo versus Illinois goes all the way up to the Supreme Court, and Escobedo wins because if you are being held, then you have the right to a representative during any form of police questioning. Otherwise, you have the right to remain silent. So you could see the building up of things you've seen on your Law and Order episodes. Here's another one. This might be the most famous, and it was like a drum roll to get there. We are in the mid-1960s, and Miranda. So Miranda also caught in some illegal activity, some violent activity. So let's not root for violent people. He admits to the crime verbally, and then he writes, they write it all up, and then he signs it. He's a confession. He signs a confession. He admits to the crime. However, they never let him know any of his rights, such as the right to remain silent, the right to a lawyer, a right to counsel, even if you can't afford it. And without any sort of fanfare, this is where the Miranda statement comes. The Miranda statement: you have the right to remain silent. I'm reading it. I don't want to mess up. You have the right to remain silent. If you give up the right to remain silent, anything you say can and will be held against you in the court of law. You have the right to an attorney. If you desire an attorney but cannot afford one, an attorney will be obtained for you before police questioning. That's one form of the Miranda statement. Sometimes it ends with, "Do you understand these rights?" So just imagine, I'm going to take a sip. You're about to arrest somebody. You're going to put them in the back seat of your car. If you don't Mirandize them, that they have the right to remain silent, that they have the right to counsel, then you are not giving them the protections that these court cases have deemed that they've earned. For example, you have the right to a counsel. Well, that's part of the 6th and 5th Amendments, part of a trial, and the part of you have the right to not say anything against yourself. So basically, from our Bill of Rights, these court cases are emerging. Now, yes, Earl Warren is also the same Supreme Court justice back at the Brown case, and he will still be a Supreme Court justice at the Tinker case. We've already studied Brown. I have a different video up for Tinker. I want you to understand that people like Eisenhower were not very proud that this supposed to be conservative justice seemingly was leaning to the left, protecting the individual rights of all these criminals. But understand, any one of us can be considered a criminal, and we need to protect everybody's rights. So we can't have the government or the police or our employer, just people pointing fingers at us. Now, those are a bunch of court cases protecting the rights of the accused. I have two more Supreme Court cases I want to address, and then I want to say goodbye. Engel versus Vittal is a Supreme Court case where the school, this is kind of changing completely to the right, where the school was mandating school prayer. When I was a kid, back in the 80s and 90s, we had the Pledge of Allegiance and we had a moment of silence. We did not pray at my school. But when my mom went to school, there was prayer. So back in the 50s. So do understand, there's a separation of church and state. The government cannot promote the establishment of a faith, thus the Establishment Clause. So in Engel versus Vittal, the idea of bowing your head in prayer has been ripped from public education. Obviously, it could happen in a private school. Tied to that is Abington versus Shemp, Abington, PA. Abington, PA banned the use of Bible readings. For example, let's start the day with a passage from the Bible. Everybody get out your Bible. It doesn't sound like anything that would happen in our school, but it absolutely happened in the 50s and 60s in certain public schools. Again, you can't do that. So this is why, if you ever heard of a baccalaureate, before a student graduates, the night before or 2 nights before, a bunch of people from the same school will gather for a baccalaureate service. It's a religious service, but it's like a non-denominational service. You're going to have all the different faiths represented. God will be very vague and ambiguous, but nonetheless, it's a religious service. You are not going to see baccalaureate services done on public grounds. You're going to see them at a local church, like our local Lutheran church, I think, holds some of our baccalaureates. Now, I have one more. Oh my God, I forgot I have one more. So this is Griswold versus Connecticut. How did I forget Griswold versus Connecticut? Griswold versus Connecticut sues because Griswold was being accused of taking birth control pill, which at that time was considered illegal in Connecticut. You weren't allowed to take any medicine, anything into your body that could affect pregnancy, because it was unnatural to do that, they thought. So Griswold versus Connecticut was a Supreme Court case basically legalizing this concept of birth control pills. Let's backtrack. So Griswold, Abington, Engel, and all of these Supreme Court cases that I'm going through today, they were all national rules. Anytime you go to the Supreme Court, it has a national effect, not a state-by-state effect. So what were the effects of the Warren Court? Well, the federal power was strengthened at the expense of states. Different states couldn't pass different rules. The federal government was in charge, the Supreme Court. It was increased rights for the accused, increased protections for the individuals. Don't forget to watch the Tinker case. Now, there was a conservative backlash to all of this because of the activity that the government seemed to have. The Supreme Court seemingly was passing rules or laws through its verdicts, affecting the day-to-day lives of not only the federal government, but each individual within the state. And a lot of these set a precedent for today. In fact, we live in a world today, 2000 blank, whenever you're watching this video, that was directly affected by all of these Supreme Court cases. And you don't even know of a world where we do pray in school. You don't know a world where the rights of the accused aren't said at every episode of Law and Order. All right. So this is to you. Have a good one.